Okay, welcome back, everybody. It's a strange world when LinkedIn sends you a message that says, "See the best advice Martha Stewart ever got." I'm kind of more interested in the worst advice she ever got, perhaps before she went to jail. Okay. Wow. Week off and I don't remember how to use this anymore. So welcome back. Hope you guys had a good break. We have Roxanne Christ from Los Angeles, who's going to speak to us in the second hour and make a liar of me, because at the beginning of the course I disavowed the relevance of gambling as part of video gaming, and that with the direction Zynga has been going in was just a really bad call on my part. So Roxanne is going to address that topic from a legal perspective. And she will tell you a little bit more about her. If not, you can just go to the syllabus and you will find a link to her bio. You'll notice a bunch of changes on the blog, thanks to everybody who's been participating. And today we are talking about technology. We've been focusing up to now on connecting, but we've been looking at the legal modality of contractual connecting for the most part. Today we're going to look at where it's going and what that might mean from a legal perspective. And I'll share a few things on that. But before we go there, and assuming I can actually get this to work, I think we may have a dead battery. All right. Sorry about that. I think I'm going to have to do it from here. No, that's really odd. I have no idea. Now it's working. All right. As batteries go, it's always on the technology lecture that the technology acts up, right? One of the things I suggested I would do was give you paper topics, and have been working on that, but kind of wanted to make it more interesting. And so I'm proposing to do paper topics as exam questions so that they're not just being spoon-fed. Here's 10 paper topics. So I'm going to write 10 exam questions. This is one of them. If you have any objection to this kind of way of doing it, please let me know. But I think it makes it a little bit more entertaining and a little less spoon-feedy feeling for both of us. This question, for example, comes out of the recent stories about Sony and Microsoft developing patented technologies that don't require an online connection in order to ensure that used games are not played on consoles. So it's outside the EULA, it's outside the contractual terms, it's a pure technological mechanism. Sony has disavowed and since gone back a little bit on their disavowal and made it a little bit more vague as to whether they're going to implement an anti-used game strategy. But the question really goes to examining cases that are in the textbook and that are available to you in the course materials and elsewhere, and looking at reverse engineering that sort of technology and all the cases around hacking Xboxes and hacking technology come into play. And it's a good paper. So that's an example. So if there are no objections. So this is the last talk under connecting. Next week we move to controlling, which is a good topic in a law school. But today we're focusing on the technology that connects and what it means legally. Okay, I'm about to really give up on this thing. All right. If somebody wants to put a new battery in it, I'm going to have to do this from here. And I apologize. And I apologize to Saeed. OK. So some perspectives. I am not going to tell you exactly how the law is going to interpret the future technologies, because I don't know. And the lessons from the past are that you can't know. So what we're going to do today is talk about the lessons from the past, and one in particular that I want to focus in on, where you can see the courts wrestling with something that turns out not to be as logical or as manifest or as obvious as it first appeared. And then I want us to remind ourselves of that lesson as we go through the various evolutions in technology that we are currently witnessing, and which do reveal, I'll suggest, a certain pattern, so that we may recognize where all of this is going. So this is loosely based on George Santayana's phrase, a well-known thought, those who cannot remember history are doomed to repeat it. So we're going to start with remembering a little bit of history. And the history has to do with something called the 507 patent and a case called Magnavox, which is the box on your left, and Mattel in television, which is the box on your right. So the Magnavox was the aggressor in this lawsuit. Basically, we're talking about a version of Pong. But a version of Pong before there was Pong. And in fact, Atari was not entirely impressed with what Magnavox had done from a gameplay perspective and sought to improve it. And you will see that in this chronology. But I've got to take you all the way back. Got to take you back to 1962 at MIT. And the first computer game, the first digital game of significant note. May not be the actually first digital game, but it's the first significant one. It was called Space War, and it was programmed into a PDP mainframe computer in 1962. and a group of students and professors at MIT played it. And it was a space game. It was a space shooting game. And pretty standard for that idiom. It was quite cool. You can find emulations of it online very easily. Now, the 507 patent, which is the core of the tale we're going to talk about, was based on research done by an employee of a company called Sanders in 67, 68. Sanders and Magnavox entered into an exclusive license agreement in 71. And the 507 patent was not a computer chip. It was an analog circuit board design. Magnavox introduces the Odyssey, which plugs into your television in your living room, and your kids play it. And this is all very interesting just from a personal perspective. In 71, I was in grade 9. In 72, I was in grade 10. In 75, I was in college in Quebec. In 76, which is when General Instrument introduced a microprocessor, a computer chip that allowed a TV game, I was in first-year law school. So this is my history as a kid coming to life. Atari comes along. I remember the first time Pong was installed in the local bowling alley, and I loved it, and I played a lot of it, and I sunk an awful lot of coins into it. Magnavox comes along and sues Atari, and Atari settles. In 78, Magnavox introduces a microprocessor. And then, and I remember this well because I went out and got one, and I loved it, in 79, when I'm in third-year law school with my buddy Peter Hamilton, we used to play endless hours of Intellivision. My marks reflected it. He was our gold medalist, and his didn't. Mattel did the Intellivision with a General Instruments microprocessor. So now, here's what you got. You got Magnavox developing the first console attached to a TV based on analog circuit board design. You've got General Instruments and Mattel together doing the Intellivision based on a microprocessor, but attached, again, as a console to a television. So what did the court do? This is really interesting. And it's not going to make sense to you from today's perspective. But I was there, and it makes a good deal more sense from a historical perspective. Because from a historical perspective, a mainframe PDP-1, which is roughly 7 feet by 7 feet, and a television screen in the living room of your house are going to feel entirely different. So the court did something. Again, from today's perspective, you're going to have some compassion. But they started out strong. No distinction between analog and digital. Court said, I regard analog and digital circuitry as two means which are interchangeable. The point is it got there. I'll explain the wheelbarrow concept, but the wheelbarrow concept says it doesn't matter how the content gets there as long as it gets there. Old CEO that I used to work for by the name of Ray Peters, who's a legend in the Canadian broadcasting industry, used to say that. And he's the one who said, I don't care if it's delivered by cable, I don't care if it's delivered by telephone, I just care that the content gets there. It can be delivered by wheelbarrow for all I care. So this was the wheelbarrow concept. Doesn't matter if it's analog or digital, as long as it gets there. Okay? I think even from a current perspective, that holds up quite well. But what happened was Magnavox was met by the following argument from Mattel. Mattel said, you, Magnavox, and the 507 patent is not the prior art to look at. The prior art to look at is Space War. That's truly the first video game. And that's what we're talking about here, video games. And the court rejected that based on physical factors. The court said, this and this are totally different. Now, from today's perspective, when we're walking around with these, it doesn't look so different. This probably has more power than that thing does by a factor of 10 or a factor of 100.
Doesn't that thing have more power than a space shuttle?
Yes. But put yourself in the shoes of the judge. And it's really important that you do, not just so that you can learn about this interesting case, but so that you can do the analysis going forward, which is what we're going to do for the rest of the class. So the court said Mattel did not follow Space War, but was only interested in the television business, in games to television. Now, with the benefit of hindsight, that may not make a whole lot of sense to us. But there's some important and difficult things that happen. There was a legal bifurcation of computer games and console games. And it actually affected the culture of the two communities. And console games were identified as apparati attached to a television. And computer games were that sort of dark, murky, free world beyond regulation. Console games were not regulated, but maybe they could be, maybe they should be. And certainly, because they were attached to the television and because they attracted a young audience, they had a very different feel. So I throw this out at you. This is a section of the Canadian, this is definitions under the Canadian Broadcasting Act as it currently stands. But just in the what would you do category. Broadcasting means any transmission of programs by means of telecommunication for reception by the public by means of broadcasting receiving apparatus, which I'll cheat for you, means television. Program means sounds or visual images intended to inform, enlighten, or entertain. So pick your favorite massively multiplayer game, put it on an Xbox, attach it to a television, and is it broadcasting? You're the judge. A little tougher now, a little more compassion for the judge in Magnavox and Mattel, perhaps. I'll use World of Warcraft because we talked about it a lot. But this issue of whether it's broadcasting, it might be in Canada. There is a CRTC exemption order that deals with digital content. So for practical purposes, that's why we don't have regulation. But the regulator has asserted the jurisdiction. The exemption order just means they're not using their jurisdiction. They're not exercising it. Doesn't mean they don't have it in their view. Anyways, you can look at that one on the slides. Now let's go to the future, armed with the lesson of the past. So this is telling, and I don't know how intentional this is, but whether it's a subconscious slip or intentional would suggest to you it's important. This is at the CRTC hearing where Bell unsuccessfully applied to take over Astral. And the CEO of Bell said, Bell's strategic vision is that it will deliver content to Canadians on all 4 screens: TV, laptops, smartphones, and tablets. Now, whether my big computer no longer exists, and in a way it doesn't, because that big screen is actually attached to my laptop, which is sitting over there. So Mr. Cope may well have a point. And it's worth, just in terms of some of the stuff that's up on the blog and some of the things we'll talk about, the Steam box, which you'll hear a little bit more about, is basically just a big computer. The PlayStation 4 that's just been announced, even though we don't have full specs on it, is using pretty conventional computer architecture, unlike the PlayStation 3. We obviously won't know until April what Microsoft is doing. But chances are they're going to remain within the PC-like idiom. So it may be that the game console is simply going to become your computer.
Yeah, curious. I remember reading once that the reason gaming consoles also don't jump into straightly delivering television as well is because the television industry has been relatively protective of its hardware and its content delivery, that sort of thing. It doesn't want game consoles or Apple to come in and offer Apple TV kind of thing. Is that your experience? Any insight into that?
Well, I think it is like everything else. It's breaking down. The music industry resisted iTunes. The Beatles came on last year after noticing that, or somebody I think noticed that after decades of being front and center because they weren't available and their music wasn't available on iTunes, a generation was falling a little out of touch with them. I'm guessing that's the motivation, but that certainly seemed to happen. To my kids, the Beatles are another band. Good band, but that certainly wasn't our experience. The Beatles were the central core around which everything else revolved, musically, including the Rolling Stones, including the Who. Perhaps not in Mick Jagger's mind, but to most of the world. So here's where we are. Xbox, and this goes to your point, Andrew. Xbox was the first to bring in Netflix. So Netflix was having the same tension with the broadcasting business because they were, in a sense, iTunes for television and iTunes for movies. And Microsoft forged an alliance with them. And the Xbox received Netflix, and Netflix basically jumped over cable. Now, the other thing that's going on, and just to answer your question really directly, is because of vertical integration. So Bell Astral, which is going to come before the commission again by all rumors. If they haven't filed, I believe they're going to be filing soon. Is an example of a telephone company continuing to acquire content companies. When you have that kind of vertical integration, the phone company is also involved in the ISP business and involved deeply in moving bits around and derives significant profits from that. And derives significant profits from moving entertainment content around over cell. So they're a little bit friendlier to a Netflix than their content subsidiary might be, because they're making money moving those bits around. Now, whether that's worth the price of the vertical integration, those are issues for the CRTC and the competition branch. And we will actually be talking about some of those issues next week. The interesting piece, the most interesting piece to me is the Steam Valve box. And I've given you a link. And it's a very interesting attempt to create a more open source platform that is not Microsoft, that is not Sony, and that attaches to whatever screen you want. Apple is an ecosystem, and this is just a personal note because I am surrounded by my own Apple stuff, without a controller. So until they figure out what their control mechanism is, even though they're through their app store, they are by far the largest provider of casual games. You know, just try playing a serious game on your computer and streaming it over AirPlay to your TV through an Apple TV. It can be done. I've got the pieces. It feels pretty laggy to me.
And sorry for my ignorance if this has already happened, but would developers of some of the apps or some of the games and also then try to create their own controllers that would be useful with the Apple system so that you can sort of like open source in the hardware as well as the software? They are.
And if you look on the net, you'll find various articles. The problem is matching the software and the hardware. So you can produce a controller, but it will only work with certain software that accepts it. because it hasn't been implemented as an Apple standard, which is the challenge in that kind of a closed environment.
So it sounds like more of a standardization problem than Apple be able to control that by, if they say this is our controller, this is our standard, design your apps and games for us, they win the market.
You would think they would, and the question you can ask as a gamer is, why does it take so long? Why haven't they done it already? It seems obvious. You'll find lots of articles on that very question. I'm not in any way the first one to do that. Ouya is an Android-based game console that has been funded through Kickstarter and has a lot of momentum and a lot of appeal to the Apple development crowd, those small developers who can develop things inexpensively. And because it's an open platform, there's a lot of appeal. We'll have to see when it's actually released. I've seen the dev kit because Kim Voll at the center has one, and it's pretty cool. But let's see. I will buy one. It's supposed to be 120 bucks. So let's see what happens when it comes out in a month or two. Sony just announced the PlayStation 4. Find lots of stuff on the blog about that, including the full press conference if you want to sit through hours and hours of marketing talk. And we're going to get to Google. Because you may say to yourself, what does Google have to do with games? And by the end of this, you'll know. Okay, just a quick point. This is just my stuff, which doesn't really matter, but my surprising reality, although I don't have any Sony stuff, is that I game on Apple, I game on Steam, and I game on Xbox. So Steam, Microsoft PC, Microsoft Xbox, and Apple stuff. And I expect them all to interoperate with each other. And interoperability, which may not sound like a hugely legal concept, is a great paper. And there's been some good work done thus far around what are there arguments that are there competition law, antitrust arguments that require degrees of interoperability in this digital world? So I'll write that one as an exam question. Okay, just want to make a point now because this is all very broad. So let's take it down to a specific example, and I apologize. I'm going to use the example of sports because it's one I know, it's one I've worked with, and because I think it has certain compelling qualities. It's live, it's highly tribal, and metaphorically, it works very well as a cousin of video gaming. These are all games, so they all kind of tread in the same geography. And for the purposes of analysis, that may help us. And if you're a sports fan at all, you know there's limitless information and data and stuff. And that works very well in a cloud-based, limitless digital world. Just want to remind you of one small fact that you probably wouldn't know. You may. I didn't know. But the launch of television in a public space was very much about sports. And at the New York World's Fair, they used baseball as the showcase event. And there's just a footnote, pretty famous case copyright case called Canadian Admiral and Rediffusion in 1954, which was where a cable company used a Montreal Alouettes football game to showcase the abilities of cable in its showroom. So sports has always been a focal point of all of this. Not going to go through this. You can read this on your own, but this is just my list of apps, of applications, of particular things that you might want to see coming through your screen and your video game console if you're a sports fan. And these are not, some are games, some are tools, some are who's in the crowd, just control mechanisms. But they give you an appreciation, I hope, of the degrees of interactivity if you're going to use this as an example. And then I've got the full-on holodeck wish list, which is really everybody's media room, or the media room that many of us dream about. When we built our house about 17 or 18 years ago, and I worked with the architect to create an alternate plan for the basement as a joke on my wife. And we took everything in the basement, including the closet space, including where the washer and dryer was, and we made it really, really tiny. And we just turned it into a gigantic media room. And we presented it to her. And she knew immediately that we had worked together on it and that it was a joke. There's very little. If you're married to the right person, there's very little they don't know about you. And also, I was laughing so hard that it wouldn't have been very hard. So why am I taking you here? I'm taking you here because before we get to the big problem, let's make some observations about the small problem. Sports through a video game console in your living room is a relatively small problem. It's one that people are working on today. So before we get to the gigantic stuff, let's just look at this for a minute. Anybody want to suggest what the big issue might be? Preferably without looking behind. Okay, the big issue is you're taking, remember Tyler's first post on the blog? It's about inputs and what happens to those inputs. It's all about inputs and outputs, and hopefully I will prove that correct by the end of this talk. Well, the legal issue is you've got multiple inputs, all appearing on the same screen. However you want to work this kind of crowdsourced live event sports programming thing, you're going to want versions of Twitter going up there. You're going to want to have the game or versions of the game. You're going to want to be able to control your camera angles. You're going to want to have some digital version of the game. I don't know if anybody, this weekend, I was in the office where I am a cord cutter. And you guys probably know I'm a race fan. And I was a little frustrated because I am a Danica Patrick fan and a Dale Earnhardt Jr. fan. which makes me very typical. And I was frustrated. I'm in the office, and I can't watch the Daytona 500. So I go to something, and I purchase something called NASCAR Race View 13. Go look it up. It's available on all platforms. And it's basically the video game version of the race. And in circa 2003, 2004 computer graphics, I have the race live in front of me and the radio feed of the race.
They just want the mic unmuted so they can.
That's okay. And the radio feed of the race, and I am watching, listening to it. No, I'm not seeing it on television, but I'm having actually a pretty good experience. Danica was in third up to the last lap, so it was pretty riveting. I will have to sit there with the app, watching it on television to see how close or different it was. I didn't get to know this time. But you're going to want all of those things. So you're merging a ton of different sources, many of whom are people, many of whom are audio sources from other places, highlights, people in the crowd sending stuff. About a zillion rights issues in this. You guys all know what Ratatouille is, right? You just throw everything into the mix. This is legal Ratatouille. So what standards are you going to apply? There's different standards if you're an ISP, a publisher, a creator. This one screen has elements of everything. And unless you absolutely track every source, where are all the rights going to be cleared? So, and then if you just want to step completely over the edge, please read the brilliant James Grimmelman's article, Why Johnny Can't Stream, How Video Copyright Went Insane in the United States. Does not apply in Canada, but you will find the peculiarities of the law amazing, and you will see yet again how easy it is, a la Magnavox and Mattel, to make a small mistake, simply because you don't have the benefit of hindsight, which none of us do when you're sitting on the bench making a prospective decision. Okay, so that was the easy stuff. Now we get to the hard stuff. So again, from the first blog post, this is my reframe, and I hope I do it justice. What's next for games? Synthetic as opposed to artificial. Reality with sophisticated inputs and outputs. I'm going to argue for the next 15 minutes that that's entirely correct, but has a surprising directionality, which is quite obvious. I'm going to try and get you there. So, got to start with a failure of a game in terms of commercial success, but a brave failure in my view. A game called The Majestic from EA, which was an alternate reality game. Great tagline. It plays you. And It was sort of cloak and dagger conspiracy theory game. But you weren't playing within the game. You would get emails, you would get messages, you would get faxes, all as part of the game. So it started blending, it attempted to blend inputs and outputs. It started to blend your digital inside the game world and the real world. And you've all heard, and I've talked about previously, the notion of the magic circle. The magic circle is that idea that within the game, that should be a safe zone, and we should all be able to play. Well, when you start playing in the world, what happens to the magic circle? Just because it was fun, I did a collection of inside the game films, because it's such a classic meme. If anybody, I'm sure I've missed a bunch, but if anybody's got some suggestions, I will revise the slides to get them right. The obvious one is Tron. You're literally inside the game. So your real world and the game world merge. Classic sci-fi meme. Okay, so let's gently go down this path. And you may not think 3D printing is gentle, but it's actually easy. Because 3D printing, though always an opportunity to recast intellectual property, copyright laws, it doesn't provide, at least in my view, a particularly groundbreaking, mind-altering change to hook an overhaul of our current laws onto. Good article there from Public Knowledge, that about 8-9 pages that will take you through IP law as it relates to 3D printing. Next place we go, virtual reality. Current piece is something called Oculus Rift. It looks like big ski goggles, but it's really, really good virtual reality. But again, it's taking the computer screen and grafting it to your face, in a sense, so that you feel completely and utterly immersed. So it will change your feeling. You will feel like, much more so, that you are really in the game. But there's no doubt you're still in the game, and you cannot function doing it. You can't drive a car. You can't see anything except the game. So you're in the game. You're in a better environment, and the founder has, I think, just one of the greatest names of all time, Palmer Luckey. So then we go to virtual currency. Now it's starting to get a little tougher. Because remember, not only do we have currency laws and tax laws, but we also have end-user license agreements that are mediating the value and the constraints on these in-game currencies. But make no mistake, the in-game, and we've talked about some of these cases, the in-game and the real world very much merge because the in-game currency has a real-world value. And whether the end-user license agreement says you can trade it or not, trading does happen. And conversion from in-game value to real world money does happen. So we're starting to see where this is going. There's a merger. And it's an interesting patent application from Sony recently. This is not the first one of its kind, but basically it's a form of camera where you take a picture of an object and it turns that object into a 3D object and inserts it into the game. Inserts it into your game. So now, again, this is the real world coming into the game. Still not quite the world, we're not really quite even back at Majestic, where the game goes into the real world. Now we get close. Anybody seen Google Glass? Anybody actually worn Google Glass? Okay, go online, check it out. It's, please, no. But there's a fabulous article from The Verge where that came out last week, where a journalist did wear them. And it seemed to have changed his life. And
I definitely heard not necessarily Google Glass, but video games being developed that have actual like a program for kids, and then the kids can on their mobile phones or something.
Yep.
Platform be running around and as they're interacting with the physical world, the game that they're playing interacts with the virtual world. And I can see something like that being an application that Google Glass gets into one game.
well, we're about to go there. Right now, when you look at Google Glass is a computer through a tiny screen, but with full-on audio and video and voice recognition, and just allows you to navigate the world and allows you to take pictures of everything in the world and allows everything that you take to go up into the cloud because Google works on a cloud paradigm. So just hold that thought. But Google Glass is compelling, and it's a way of taking the digital world out into the real world. And then I got to throw this in. There's a Kickstarter project called Throw Trucks with Your Mind. This actually works. This isn't the first iteration of it, but basically you use the pulses in your brain as your video game controller. Go there, check it out, it's real. Now we get to an article that suggests that what's really happening is that our lives are going to be real-time Twitter. All data, all information is going to be in front of us and streaming all the time. And that's, in a sense, what Google Glass enables. This is a think piece, but an important one. I want to add just a couple of very small pieces to this that are technological, but important. Wi-Fi has grown in terms of data transmission to be almost equal to cellular. And if you reflect on that, that's really, really profound. Because obviously, there's tons of data that all this takes up, and we are finding in Wi-Fi how to do that, and how to do that at a relatively manageable cost. The cloud creates jurisdiction issues. Good legal article on that. But creates a whole bunch of privacy issues that we're going to talk about in 2 weeks. And then finally, I'll take you to Google's self-driving car. There's a lot of Google in this, and that's not intentional on my part. But I will try and tie it together. So they've been working on a self-driving car that works. It really does work. It hasn't had an accident, as I understand it. And they've done tons of testing. It's about 3 years away. So now we're starting to get close to, there's not only you, but there's your ability to control a form of bot in a pretty profound way. Think of that from a gaming perspective.
I was just going to say, yeah, you can have your race cars in real life there.
Race cars, war games,
Yeah.
but this is all the real world.
Google Tank.
So how are we, Google Tank. So how's that going to work? So all of this made more complex by a series of factors that the law has something to say about. Anonymity, virtual goods we've mentioned, and our favorite, patents and software patents and trolls, and all of those complexities that we've talked about. And then, just because so much of the class has been taken up by it, who's the author of all this when you're in a merged screen? Who's got the copyright? This is the game meme. There's multiple creators. The people playing, the people who've designed the game. Now take this all up to this level of complexity, and you get the big version of legal ratatouille. And there's my picture. I'm going to focus in 5 minutes on a couple of very particular problems. So you know when you look at a television and the television has got a picture of a television and another picture of a television, another picture of a television. Sort of the infinite television screen. There's a case, where things appear logical but aren't. I call that the Escher conundrum. I did find a free copyright wiki picture, Escher picture to put up there. Things seem logical, but they're not. And what do you do about them? So this is a great case, undecided as yet. Escobedo versus THQ. Escobedo is a tattoo artist. He did a famous tattoo for a UFC fighter. The UFC fighter's character appears in the UFC game. The fighter had no problem with the tattoo appearing in the game. The tattoo artist did and sued THQ, who made the game. What would you do? Easy to make mistakes. EVE Online, the Magic Circle game, suspends ethics for the most part and allows intentionally. And is, by the way, one of the few games where there is a ton of academic work being done. And just for your amusement, I've included a call for papers from one of the conferences on EVE Online. And now we get to the point. I have a colleague at the center, and he's a pretty good friend, and he's a wonderful, wonderful guy, and you know him. And he's not really a gamer. And the last week, he's been very distant. And he's been walking around with his Android notebook. And finally, I said to him, "What are you doing? You're walking around the campus compulsively with your Android notebook." Well, he's playing a game from Google called Ingress, which is still in beta. And it's a capture the flag in the real world game. And it's obviously very compelling because this guy who knows a lot about technology and a lot about digital content, he's not really a hardcore gamer. And I can tell by that faraway look in his eyes that he's hardcore. This is me playing Grand Prix Legends in '97. This is you playing Doom. This is, this is that thing. And we as gamers recognize it. And that's the map it generates, and it's massively multiplayer, and it all happens in the real world. And you attach that to Google Glass, and you attach that to the cloud, and you attach that to all the data that's being created, presumably by millions of players who will play this incredibly addictive game when it comes out of beta. And then try and think about the legal consequences of that. Because this is much more difficult than Magnavox and Mattel. And we will, over the next couple of weeks, as we talk about controlling, start parsing out what kinds of controls we can exercise. Competition law, privacy law, regulatory mechanisms. What's the role of intellectual property law? What's the role of contract law? But in this world where gaming is moving into the real world, what happens to the magic circle? The notion that real world laws shouldn't apply to the virtual world is starting to feel antiquated. But then we've got to be really careful about what laws we apply and how we apply them. And that's the challenge of the future. And this is just the final slide. What we're seeing and the legal consequences of it are unknown, is a direction reversal. We used to have the real world comes in, gets transmuted into our digital world. Our digital worlds. So that's what it used to be. This is what it's becoming. Our digital worlds are becoming our real world. And we know that because we're joined at the hip to this and this. So it's happened in part already. But it's about to get much more compelling. And that's where we go next week.